If you make $200,000 a year, you pay $70,000 in taxes. So buy an Airbnb instead and pay zero tax. That's the claim of the post. Now, Chris, what do you think? Are you skeptical or are you a believer?
Skeptical doesn't even begin.
Welcome to Silberman Law Firm's Weekly Docket, episode 66. My name is Phil Silberman. I'm your host, and today is April 16th, 2025. And normally I'm joined by my co-host, Austin Black, but a little bit of sad news. Austin resigned from the firm and he started his own law firm. So he's really no longer able to do the show. We may have him on later as a guest, and we may bring Austin on to say goodbye to the listeners at some point in the future. But got Chris Heald, who's the firm's supervising lawyer. He manages all the attorneys. He's agreed to step in this week and fill those shoes. Chris, will you ever be able to fill the shoes of Austin Black with laughter and joy and enthusiasm for the weekly docket? Can you do that for me?
I'll do my best.
He's going to do his best. Okay, that's all we can ask. But anyway, very happy for Austin starting his own firm. We may bring him back, but Chris is stepping up today for the show. On our docket today, we've got some cool topics. First thing, we're talking about a little legal news. Mays Middleton, who we just interviewed on the show, has recently announced that he's running for Attorney General. So we'll talk a little bit about that. And then we'll get into our legal questions section. We're going to answer a question about why everybody who buys expensive cars is registering them in the state of Montana. And then we're going to talk about something Chris knows very well, probate. So we're going to talk about whether or not you can probate a will after someone has been dead 4 years. And Chris is going to educate us on that. And then we'll get to my favorite part of the show, which is our rant and rave section. And we're going to be talking about dispelling some more of these social media myths about being a real estate investor and all these amazing things you can do from a tax standpoint. So a public service that I do where I dispel these social media myths. So we'll be doing that. So it sounds like we've got a good show. Should be a short show, but we'll see how long it takes us. Let's get it kicked off with our legal news section. And the first thing we're talking about is Mays Middleton running for the Texas Attorney General. So, Chris, that was Ken Paxton. Are you a Ken Paxton fan, Chris?
Hot take. I don't know anything about Ken Paxton.
Nothing.
I think he's disliked because he did something, but I don't know what it is.
Okay. Did you know that Ken Paxton is now running for senator? Yeah, he's going to run for U.S. senator. He's going to try to overtake John Cornyn, who has been a longtime U.S. senator for the state of Texas, but not very well liked among conservatives because John Cornyn has always had the label of a rhino. Are you familiar with the term rhino, Chris?
I am. I did not know that was the reputation Cornyn had.
Yeah, absolutely. He's had that reputation. So I think Ken Paxton is going to run. And you're correct. Ken Paxton has not had the cleanest of all histories. He's not exactly, what do you say, a choir boy. He's been accused of some, I think, insider trading, maybe some securities issues. My favorite story, though, is I think years ago when he was an attorney and he was going down to the Collin County Courthouse, another attorney had left a Mount Blanc pen valued at $1,000. And there was some surveillance footage where Ken Paxton just takes the pen, right? So he takes this $1,000 pen. Had you heard of this before, Chris?
I had not.
Now, I don't know if it was in security. You know how you go through the metal detectors at the courthouse? So it'd be like if you just finished trying a case or doing a hearing or something, and you're going through the metal detectors and the opposing counsel leaves the pen in the little bucket, right in the tray. And you're like, that looks like a really nice pen. I'll just grab that. And then pocket it, and then it came out that he did that, and then he returned the pen and said, oh, it was just a mistake. I promptly returned it to the other lawyer, but I don't know exactly that's how it came down, but that's what he did. But we digress. Ken Paxton is running for U.S. Senator against John Cornyn. That leaves the Attorney General spot in Texas open, and we just interviewed Mays. He's currently a Texas senator, and we interviewed him on Senate Bill 379 and Senate Bill 2. Senate Bill 2 is school vouchers. getting school choice in Texas. Senate Bill 379. Mays sponsored that bill, Chris. That's the junk food bill, where we don't want poor people in Texas on food stamps using food stamps to buy junk food. Are you a fan of that one? What do you think?
I had not previously heard of it, so forming an opinion on the fly.
Yeah.
None of us should be eating junk food at all. So I'm not usually a fan of the government telling me what I can and can't eat, but also none of us should really be eating junk food. It's pure garbage.
Yeah, it is. Mays had a good little tagline on that Senate Bill 379. He said that taxpayer-funded junk food ends up being taxpayer-funded healthcare. That was his stance on it. So now you bring up a good point, though, and I'm really a libertarian at my core, and I don't feel like the government should be telling us what we should and should not eat yet. But this is a little bit different because the government is paying for the food. The taxpayers are paying for the food, right? Anyway, he had a couple of good bills there, 379 and Senate Bill 2. Senate Bill 2, by the way, is much more controversial. You've got kids in public school, right? So
Yeah.
that one was about giving parents choice. And if you're in a certain income, you're going to get $10,000 per kid to send them to private school or do other things. And it's very, very hotly contested. The people that are really pro public school are arguing it's going to take money out of our public schools. Mays was on the show, basically said, no, that's not the case. We can do both. And I'm a fan of the school choice bill, but it is a very controversial, hotly debated bill. So Mays is known as one of the most conservative Texas senators around, and he's running for attorney general. Just announced it on Tuesday. And here's the interesting thing. Let's just say Mays is not a pauper, okay? Mays has a little bit of money, and he sent out an email to his supporters saying he's immediately going to take he's pledging $10 million of his own money for his attorney general race. I wasn't sure if that was a lot of money. Does that sound like a lot of money, Chris?
Sounds like a lot of money for a regular person. I don't know how much it costs to fund a campaign, though. On a
See,
campaign,
I didn't.
It's not real money. People have to spend millions and millions of dollars on campaigns. So that's probably not enough to run a campaign.
See, I did not know either. Well, I wasn't sure like the context. I just Googled how much money do you need to run for Texas Attorney General. I did not get anything really great. I expected Gemini or ChatGPT to tell me exactly, but it did not. The best I could do is, according to Wikipedia, when after Ken Paxton won the first attorney general race, okay, he was left with about $1 million in his campaign coffers for a reelection bid. And then he ended up getting like another 3 million. So it was like 3 million total for his second reelection bid. So in that context, I don't think anybody ran against him the second time. I can't exactly remember, but in that context, $10 million sounds like a lot of money for Mays to run for attorney general. Except you probably have not heard who he's running against. It's this guy, John Bash, who is a Elon Musk lawyer. So I'm assuming John Bash, who has done a lot of work for Elon Musk, is also probably very well funded. So we're going to see how far Mays' $10 million gets him. We'll have to see. As a law firm, can we make a campaign donation? Are we allowed to do that, Chris? Don't law firms like donate to judges all the time?
Yeah, we can. It's just not tax deductible.
Yeah. I don't know. Maybe we'll make a donation to Mays in his efforts for attorney general. So I'm not going to officially endorse him at this point. I've got to see some more things on what's going to go on with that campaign, learn a little bit more about John Bash. But on the face of it, I think I'm liking Mays a little bit better than John Bash. But if Elon Musk starts throwing money at that race, who knows what happens. I don't think John Bash is a pauper either. But all right. So good luck to Mr. Middleton and his bid for attorney general. We certainly appreciated him coming on the show and answering questions about what he's doing down this legislative session. But that brings us to our next section. This is our legal questions section. And this came up because I had a buddy of mine and I saw him get into his car and he had this EV electric Hummer thing. Have you seen these, Chris? Do you know what these look like? These electric Hummers. It's a Hummer. Okay, we used to have a Hummer. It's a General Motors product. It's an electric vehicle, and he had this Montana license plate on it. I said, why on earth a guy who does nothing to do with Montana is registering the car in Montana? Why does he have this Montana license plate? And it piqued my curiosity. I looked this up, and it turns out all of these people are registering their vehicles in Montana because Montana has no state sales tax on vehicles. So in Texas, if you go down, buy a vehicle, you're going to pay 6.25% sales tax. You buy a $100,000 vehicle, it's a little over $6,000. You do that in Montana, zero tax. Is that a good deal? Maybe. There are some other benefits to it. Montana also has no state inspections or emissions tests. There are some negatives to this deal. You're going to have to ship the car from Montana to Texas, which is going to cost you somewhere between $1,000 and $1,500. And then you also have to form a Montana LLC to meet their residency requirement. I don't know. What do you think? If you're buying a $100,000 vehicle, Chris, you're gonna go through that. You're gonna do all that, or are you gonna spend the sales tax?
You'll never see me buying $100,000 vehicle, but it sounds too cute to be worth it. You have to be physically there to conduct the sale, or it sounds like the vehicle has to be there.
Yeah,
I don't want dealerships just put in huge orders because they know they're shipping nationally, and you just buy in Montana.
I don't think you have to be there. I think there are these companies that specialize in this thing. I don't even think you need them. I think if we wanted to do it, or if we had a client call us, like I know you're right now forming a Delaware entity, right? So I think Montana is a very popular state to form entities in. So we could have a client call us. We could form a Montana LLC. I don't know what that would cost. The filing fee is probably pretty low, but I don't know what we would charge for. I'm not putting prices out there, but let's say the filing fee was low and we charge someone $750 for a really simple LLC to hold a car. So you form the LLC, and then I think you probably have to pay all cash because you're not going to get financing. You can't personally get financed for a vehicle and then have the vehicle held in the name of the LLC. So this is going to be limited to all cash purchasers. You're going to have to form the Montana LLC, and then you're going to have to ship the car. Is it worth it? I don't know. I probably wouldn't do it for a $100,000 vehicle. I don't buy very expensive vehicles either. I buy most of my vehicles used. But if I did have a mind to buy a very expensive vehicle, I don't even think $100,000 for a vehicle is even that expensive anymore, sadly, because you now have let's just go like a Cadillac Escalade, a Lexus LX, both those vehicles, some of these big SUVs we drive in Texas. I know it's expensive, but it's 120, 130 grand. And you just routinely, Chris, in the area that we live, you just routinely see Escalades left and right, like they're Toyotas or something.
I did mistakenly guess that someone's Jeep Wagoneer was $60,000, and they were very thin.
Oh, no. That's like worse than guessing a woman's age and having her be. You're really going to offend someone in the Memorial area if you tell them that they're only driving a $60,000 SUV, Chris.
I learned my lesson.
Yeah, now these vehicles are expensive. For me, it would have to be like a $250,000 vehicle, I think, to make it worth it, all the hassle. A lot of people out there, Chris, if you're buying a $250,000 supercar, this probably does make sense. Just my 2 cents, all right?
It's also paperwork, though, and having to do more stuff has a cost to it.
It really does, and I think we as attorneys know that better than anybody else because we fight for a living and we deal with sort of bureaucracy in the courts, and we're very commonly dragged into these nuance, whether it's a permitting process or an inspection process, and we do get tired of doing it for a living. So how much money is it worth the hassle? I always think that old saying, is the juice worth the squeeze? But all right, let's talk about something Chris actually knows about today. Okay. Can you probate a will in Texas if the person died over 4 years? I asked you about this yesterday. Give us just a little background on the lay of the land. I mean, someone calls and you ask them how long it's been since the person's died. Why are you asking that? What's significant? Just tell us a little about that.
It's significant because the estates code does set a baseline of 4 years. It does say no will shall be probated after 4 years, except as a muniment of title. And even to probate as a muniment of title, you have to show that you're not in default for failing to bring it in the 4 years. And so often we actually get people flip this around, and you'll have one sibling after mom or dad dies tell the other siblings, I have 4 years to probate this, so leave me alone. I'm not going to probate this anytime soon. It's not really designed to give you that latitude of time. It's really saying, hey, do this within 4 years. We want to get stuff done. People die, assets depreciate. We want this done before mom and dad have been dead for 10 years, because as we get a lot of calls when family just doesn't take care of everything because mom and dad wanted the land left in the family. And so we get a call, hey, mom or dad or grandpa died in the 50s, 60s, 70s. And that just makes it very complex, much more difficult to handle now than it would have been if they would have just handled it.
So you brought up a different point, different question. This is interesting. No, this is interesting too, because, and I want to ask this, what happens if you do have someone named as an executor in a will, and they say they just refuse to probate it with any promptly. And there's assets out there, there's a house out there, maybe there's some bank accounts, and they just say, you know what? I've got 4 years to probate it. I'm not going to probate it right now. What if we have a beneficiary in the will calling us saying the executor says he's not going to probate it until 3 years and 11 months? What do you say to that? What do we do? What would you propose to that beneficiary that's calling us?
There's a couple ways you can handle it. If they don't have a copy of the will because the sibling is just hiding the will, then we say, hey, we're going to file for probate with no will because they're not sending us the will. We don't know if it exists or not. They say it exists. The other option is if they have a copy of the will, we file the copy. We say the executor is refusing to serve, and then we show cause the executor to bring the original before the court, because you do have a duty under the estates code, again, that says upon the death of a person, if you know that this person is deceased and you have possession of their original will, you must deposit it with the county clerk in the county in which probate is proper. So you don't have to file an application of probate. They're not making you do that, but you must take it to the courthouse, file it for the exact reason you're talking about.
Okay. Okay. Let's say we get it down to the courthouse and it's filed, and then now the executor still won't do anything. Is there any motion we can file on behalf of that beneficiary? Can we say, Judge, hey, we're gonna probate it? Probably be a dependent administration since the executor is not cooperative. Or what would the judge say? Would the judge just say, well, no, he's not in default, he's got time to probate? How do you see that coming?
Not the way it should. So the push that I would love to see is if an executor is not voluntarily moving forward, that we move to the alternate executor. But courts don't see it my way. They want to see a waiver from the executor saying, I decline to serve. Otherwise, they say, hey, I have a first name executor. He hasn't declined, so we don't go to executor number 2. I think it should be exactly what you're saying. If I notice them and I prove that they're not getting up off their couch and moving, and I'm the alternate, we represent the alternate, they should be able to be appointed independent executor. I think courts just have their checklist and they see first name executor. They don't get a waiver from that person. They say, no, you can't serve. You have to get them to serve, or you have to get a waiver from them. I think it's unnecessarily complex.
Yeah. And what about the argument that the assets are being subjected to waste? Is that you're saying the courts have not been sympathetic to that argument?
I have yet to have one. It's not super common because a lot of times they'll either go hire an attorney or we will eventually persuade by force to get them to waive. But yeah, the courts are as sympathetic as I wish they would be. Okay, yeah, sure. It's been a year. They haven't done anything. We're fine appointing your person. They're the second named executor, so let's just go.
Okay. And that's interesting. That you brought up an additional question that I wanted to talk about. But in this case, we're talking about the opposite, where the time has passed. And normally what happens is I always say poor people die every day. It's sad. We all die, but oftentimes people die without any assets and they think that they don't need a probate. And it turns out that they're owed money well after 4 years. So the heirs or the beneficiaries in the will, in this case, are then saying, okay, now we do need to probate the will. There's a reason for probate. So they call us in year 5, 6, 7, 8, 9, 10, whatever. And they say, okay, please probate this will. And our answer is this is going to be difficult. And why we found it to be difficult is because there's an estates code section. And I've got 256.003 that says you're barred from probating this will. Letter shall not issue and if the decedent's been dead for 4 years. But there's another section of the estates code that says there's some, if as long as you're not in default and the estate's owed money, then you can do it. So you almost have this direct conflict of the law, which is not really not unusual in the law. And we still try to get it probated. And Chris, what's your experience been when we've tried?
I've had some success. I think the law changes and we have trends. And I certainly think the trend is towards not allowing probate. And I think the theory behind it is to encourage people to act quicker from a public policy perspective. How do you get the word out to the general population? Hey, courts are not going to be sympathetic to probate after 4 years. So you better take this seriously. This is just not an issue that people think about in their daily lives. You encounter it once or twice in your life, usually. And usually if it's your parents and we're lucky, you're already in your 60s or 70s by the time your parents die and you actually have to handle this. So I don't know the motivation of starting this trend and saying, hey, Texans, you better do this or else. But I have seen courts now just flat denying wills being admitted to probate, saying, hey, it's over 4 years. We're just not going to do it. But that leaves people in the spot you're talking about. There's assets out there that they didn't know about. And now someone's telling them, yeah, just go get letters and we'll distribute these assets to you. And they know that there's money out there and they're being told there's money out there. And the court's giving them a hard time because now it's been over 4 years.
Yeah. And I wonder what ultimately is going to happen to these assets if we can't get a probate done and we can't get letters issued and we can't get money into an estate. What happens to these assets? What happens to this money? And I think the answer probably ends up being that the money gets put with the Texas comptroller and probably placed in the estate of so-and-so. And then the Texas comptroller will then have processes for claiming that money. Oftentimes if it's large enough, directing them to go back to probate. Of course, that's not always practical. I think the Texas comptroller wants to get rid of this money. So hopefully they start allowing, Chris, one thing that doesn't have a time limit on this that we both know is the determination of heirship. So tell listeners real quick, what's the determination of heirship?
It doesn't now, it used to, and I've run into that problem too. So technically if grandpa died in the 70s, there was a time, unfortunately. But yes, now post 2011, yes, you can have a determination of heirship done anytime, which is just the court declaring these are the heirs of this person. And so a lot of times you're talking about the comptroller or other entities will take that as sufficient from a court saying these are the heirs, knowing that those are the only people that can claim this money. So if they know if they distribute the money to that list of people in the proportions outlined by the court, that they're not going to have any liability.
Yeah, so there's some hope. So even if we have a court that won't issue letters for a probate related to a probate where the decedent's been dead longer than 4 years, there's this process out there called the determination of heirship. We can probably use that effectively, maybe to get some of the assets to the right people, or some people anyway, the heirs at law. Okay, that's good stuff. Again, Chris is our resident expert on probate and litigation. Appreciate him answering those questions. That brings us to my favorite part of the show. This is our rant and rave section. And we're talking about buying Airbnbs. There's a social media post and use an Instagram post. And the post basically says, here's what the post says. If you make $200,000 a year, you pay $70,000 in taxes. So buy an Airbnb instead and pay zero tax. That's the claim of the post. Now, Chris, what do you think? Are you skeptical or are you a believer?
Skeptical doesn't even begin. That stuff like that is just wild.
Chris is generally skeptical of many things, but I think his skepticism is correctly placed on this one. Again, public service of mine, my wife actually sends me a lot of these. They circulate all over the place. And there's a little bit of truth in some of this stuff, but most of the time the claims are not near as good as they are. So there used to be a show on the Discovery Channel I'd watch, Chris, called Mythbusters. You ever heard of it?
I have.
Yeah. So we're going to do a little bit of myth busting here. And we're going to go, I think I'm going to carry the team on this one since I'm the tax guy, even though our firm doesn't practice tax. I really like tax. I've done a lot of tax stuff. Let's talk about myth one. All right. If you make 200 grand a year, do you pay $70,000 in tax? A complicated question. There are all kinds of different tax, but let's just assume you're a W-2 person. You work a regular job. You've got a $200,000 a year salary. How much tax are you getting? You've got this employment tax where you're going to pay Social Security and you're going to pay for Medicare. And that rate ends up being, I think, 7.65%. So you've got some tax there. And then you have just the federal income tax component, right? And you'll have this effective sort of tax rate. But you have to assume a normal situation. Let's say someone makes $200,000 a year. They've got 2 children. They're taking the standard deduction. And I did a little calculation. I'm not going to bore everyone with the tax, but bore everyone with the calculation. But you end up paying about $38,000 in tax, not $70,000. Okay, so I think we can say that myth is probably busted. You're not going to pay near that much tax of $70,000 if you make 200 grand a year. You're going to do things like you're going to have maybe an IRA donation. You're going to get some different. The standard deduction is pretty big now. You're not going to pay that much tax. But okay, moving along. The other myth that they talked to, the other claim the social media post made is you're going to get to take all this amazing accelerated depreciation instead of normal accelerated depreciation instead of real estate. You're actually allowed, you can't depreciate the dirt. The dirt doesn't depreciate the improvement, whatever's construction on that lot. You get this straight line depreciation over 27 and a half years. That's the normal depreciation. Okay. But these seminar people, they're saying, okay, no, don't do that. You get to take this accelerated depreciation. And accelerated depreciation does exist. All right. On certain things, you can take this advanced depreciation. There are some assets that, if you think about accelerated depreciation, there are some assets out there that depreciate really rapidly when you first buy them. Okay. You can think of things like certain kinds of equipment and vehicles. All that does have this very accelerated depreciation. So our tax policy sort of wants to recognize that. And now depreciation, the great thing about taking depreciation, Chris, is it's a non-cash expense, right? So you're not actually spending the money, but you're getting the tax benefit. So you want to take as much depreciation as you possibly can, as quickly as you can, because you want to defer tax. Are you with me so far, Chris?
I am. And speaking of the cars, or you talk about machinery and cars, did you guys ever talk about how everybody for the last 2 years has said, if you buy this certain car that's over a certain weight, the IRC says you can depreciate the whole thing right away. And it's this huge thing that people talked about forever. And it was really foolish. And because they went and they said, oh, the Porsche this or Jeep this, they found the cars that had the weight. But like you said, it was really for farm equipment. And so anyone who tried that probably didn't end well for them.
No, we had Brandon Friends on the show a while ago. We did talk a little bit about that. And yes, you're 100% right. And there's certain these requirements where the vehicle has to weigh over, I think it's 6,000 pounds. I can't remember what the gross vehicle weight is. And there was some, but then even that started getting phased out. Similar to this stuff started getting phased out too. So anyway, there's a little bit of truth in a lot of things. You can take accelerated depreciation for real estate, but guess what? You can only take them on certain things, right? Like floors and appliances. And that makes sense because the whole improvement probably shouldn't be subject to accelerated depreciation. But the idea is if you have a dishwasher in your Airbnb, you can take accelerated depreciation on your dishwasher. All right. Good job. You're going to have some really expensive fixtures like dishwashers, and you're going to have the flooring like lined with gold for this to make sense. And then the other problem with this, Chris, is in order to do this, you actually have to pay for a cost segregation study. So you have to pay a firm to come out and tell you which things you can actually segregate and how much those things are. So it'll tell you your dishwasher, your flooring, your refrigerator, and all that. So the cost, almost certainly the cost of the cost segregation study and all of the stuff you have, this is going to be some amazing Airbnb property, right? So for this to work out, for you to get all of this amazing depreciation. A little bit of truth in that, but these are some things you're going to have to pay attention to. I know the other thing that the seminar social media people are not telling you is you actually have to subtract the depreciation from your basis, right? So when you buy real estate, you have basis in the real estate. And when you go to sell it, you want your basis to be really high. So you've got less capital gains tax. But when you sell the property, you have to take all that depreciation out. So if you've depreciated huge swaths of value, you're going to end up adding it back and you're going to end up with a larger capital gains tax bill. They don't tell you that in the Instagram post. Okay. So the other bad thing about this is STR, short-term rentals. There's been some of these big percentages being phased out. So you're going to be limited to depreciation pretty quickly. I think in 2025, we're already at a 40% limitation. If you can get there in a cost segregation study, and then it's going to be going down to 20% in 2026. Okay. So let's just assume, Chris, that you've bought a spectacular short-term rental Airbnb. You've managed to get your cost segregation study done. You've got the firm told you're going to have $500,000 in accelerated depreciation. And now you're all ready to deduct it, to offset it against your W-2. So basically, let's say you're a lawyer, Chris, or you're a doctor and you make 200 grand a year and you're now have this doctor income. And what do you think, Chris? Can you take this big real estate loss in your Airbnb and reduce your W-2 income so you're paying less tax? That's what they want you to believe.
No. And I don't know that legally, but I know that just can't be right.
Okay. There's a little bit of truth in it, but it's not going to be easy. All right. In order for you to be able to do this, you have to meet what's called, the IRS calls, a material participation test. And here's the test. You have to qualify for one of these things. You have to have participated in the activity for more than 500 hours that year. That means if you're a busy ER doctor, you have to actually support and document that you did so many hours a week, 500 hours in a year, right? That's actually a lot of hours. What's 500 divided by week? How many hours?
10 hours a week.
Yeah, that's a lot of hours. And I have seen these types of audits before. The IRS will come through and they'll put the burden on you and they'll say, you show me the documentation for the 10 hours a week that you did. And just the general allegation that I was there managing the Airbnb and I was cleaning it, that's not enough. Okay. They're going to try to pour you out on that. All right. So you can do 500 hours if you can get there. And then the other thing you qualify for is your participation was substantially all the participation in the activities for the tax year. That means it's basically the only thing that you're doing. And most people, that's not going to work. Right. If you're a doctor, it's not the only thing you do. Here's the one that most people try to get in on. You participated in the activity for more than 100 hours, which that's plausible, right? It's got 2-3 hours a week. And you were the only one that participated. Like you didn't have anybody else participating that much. Okay. So if you can do those things, you can potentially get in this offset loophole type of exclusion. Little bit of truth in it. I'm not going to say the myth is completely busted on that one. I'm going to say that in its entirety, the advertisement that this is an amazing deal and you're going to pay zero tax by buying an Airbnb. What do you think, Chris? Based on hearing everything, are we going to say that myth is completely busted, or are we going to say a little bit of truth in it?
Zero. You're not going to pay zero tax.
No,
That's
it'd
crazy.
be hard. It'd be hard. We're going to say that claim is completely busted. One of those things, if you're probably too good to be true. there is a little bit of truth. If the stars were to align just right, you might be able to get it done. Oftentimes life is a risk reward thing. I don't know that you want to take this much risk on your tax return and potentially enter into the realm of penalties and back tax and maybe even criminal liability. Although I think that would be rare, but a lot of risk there. All right.
You just you're paying your CPA for the pleasure of filing a lot of extra documents to offset your rental income that you didn't previously have before you purchased the Airbnb. And like you said, depreciating the asset so that when you do sell it later, your capital gains taxes are higher.
Yeah, there's a lot of things that got to work well here. I don't love this idea, but this is out there on. Hopefully, we've done a public service today, Chris, and we've taught people about trying to evade. I'm not gonna say evade; that's a bad word, but we've taught people about maybe saving some potential tax liability if you're going to buy a real expensive vehicle in Montana. And we've taught people a little about some tax liability on Airbnbs and maybe some of the risks there. And with that great work that we've done today, Chris, that brings our show to a close. My name is Phil Silverman. I've been your host. Chris Hield has been my ever so gracious co-host for the day. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice. This has all been for entertainment purposes only, or tax advice. All been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. Let us know you want it publicly answered in the podcast. We will do our best. Everybody have a great Easter weekend, everybody, or Passover, or both Passover and Easter weekend.